Oh, this is Sanders. Oh. Okay, court is back in session in clause number 331868. Case is filed the state of Texas versus Lyle Sanders. Mr. Sanders, is that your full name?
Yes, sir.
Mr. Sanders, would you please raise your right hand? Mr. Sanders, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, Mr. Sanders, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Or these your initials on the line that states that you want to apply for court-appointed counsel?
Yes, sir.
I also have another document here. This document is titled Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there is a signature on a line that's titled defendants. Is this your signature above this line that's titled defendant?
Yes, sir.
And Mr. Sanders, before you signed and initial these documents, did you read the documents?
Yes, sir, pretty much. Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Sanders, I've read your answers in the affidavit of indigence, and based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and your attorney that will be appointed to represent you in this case is attorney William Wilkerson. Our court coordinator is going to give you information on how to contact Mr. Wilkerson, and Mr. Wilkerson will be given information on how to contact you. No, his attorney is Nathan Reynolds.
Okay.
Lyle Sanders, yeah. Hold on, I said Nathan Reynolds? Yeah, Nathan Reynolds. Nathan Reynolds is his attorney. Okay. Our court coordinator is going to give you information on how to contact Mr. Reynolds. Mr. Reynolds is going to also be given information on how to contact you. Now, Mr. Sanders, I also have what is called bond conditions. And in these bond conditions, these are the conditions that you'll be required to participate in while you're out on bond. Now, Mr. Sanders and state, pursuant to Article 1.24 of the Texas Code of Criminal Procedures, all trials and proceedings shall be held public. All proceedings, trial, and all courts shall be public. However, pursuant to the case of Lilly versus State, 365 Southwest 3rd, 321, the right to a public trial is not absolute and may be outweighed by other competing rights or interests, such as interest in security, preventing disclosure of non-public information, or ensuring that the defendant receive a fair trial. State, are you requesting that this portion be closed to the public to prevent the disclosure of non-public information?
Yes, Your Honor.
Okay. Now, the state, well, the court finds that the party seeking to close the hearing has advanced an overriding interest that is likely to be prejudiced to the defendant. The closure is no broader than necessary to protect his interests, that is, to prevent the disclosure of non-public information. And the court have considered reasonable alternatives to closing the proceedings, and the court findings that it makes are adequate for the support the closure. So at this time, this hearing